While giving the final verdict on the civil writ petition number 55 of 2019 in the Supreme Court of India, in Janhit Abhiyan as petitioners and Union of India as respondents, the Supreme Court on 7th November 2022 upheld the validity of the 103 constitutional amendments providing 10% reservation to people belonging to economically weaker sections, EWS, in admissions and government jobs with 3-2 split verdict, but does not include the poorest of poor among scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes from its scope. Justices Dinesh Maheshwari, Bela M. Trivedi, and J.B. Pardiwala delivered the majority opinions on the 5-judge bench in an hour-long session with minority comments from Chief Justice U. Lalit and Justice S. Ravindra Bhatt. Justice Trivedi noted that the legislature understands and appreciates the needs of its own people. The 3 judges in the majority held that reservation on economic criteria alone did not violate the basic structure of the Constitution. The petitioners had argued that the exclusion of scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes had left only the middle class among the forward castes drawing less than 8 lakh rupees as annual family income to reap the benefits of the EWS quota. Justice Bhatt said, "Our constitution does not speak the language of exclusion." He said the poorest of poor among scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes had been kept out of EWS quota on the delusion that they benefit from the existing 50% reservation and were thus somehow more fortunate. Justice Bhatt said, the government believed that including scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes members in the EWS quota would bestow them a double benefit. Justice Trivedi countered that the 103rd Amendment only created a separate class of EWS without affecting the special right of reservation provided to scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes. Even the scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes members had been treated as a separate category for the purpose of the 50% reservation. They cannot be treated at par with citizens in the general or unreserved category. The amendment certainly cannot be termed as a shocking, unscrupulous travesty of equal justice. Just as equals cannot be treated as unequal, unequal cannot be treated equally. Treating unequal as equals will offend the doctrine of equality in Article 14, Justice Trivedi reasoned. In his spirited dissent, Justice Bhatt responded that permitting the breach of 50% ceiling limit would become a gateway for further infractions and result in compartmentalization. However, both Justices Maheshwari and Bhatt agreed on the state's power to make special provisions for implementing reservation in private unaided institutions, including professional colleges. Justice Maheshwari held that the amendment cannot be said to violate basic structure by permitting the state to make special provisions in relation to admission to private unaided institutions. Justice Bhatt said reservation in institutions where education was imparted could not per se be violative of the basic structure. He said the amendment would be valid were it not for the fact that it excluded the other backward classes. Thank you for listening to the Verdict India podcast.